1 second, please. Good morning and welcome to the First District Court of Appeals. We have one case to be argued today, and that is C-230370, State v. Hurt. Could the attorneys please rise and let me know your name and your readiness to proceed?
Good morning, Your Honors. Angela Glazer on behalf of Dylan Hurt, ready to proceed this morning.
Okay, thank you.
Judy Lamb on behalf of the state, ready to proceed.
All right, you can come on forward. I will be keeping your time, and when you see the yellow light, that means you have about a minute. When you see the red light, that means that your time is up. Ms. Glazer, would you like to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 4 minutes for rebuttal,
Okay,
please.
thank you. Whenever you are ready, you may get started.
Thank you. May it please the court, the State of Ohio. I'd like to start by addressing the second assignment of error, the issue with respect to removing Mr. Hurt from his trial proceedings. I would argue, judges, that he was not disruptive and he was not voluntarily absent from the proceeding. As you can see, he was physically present in the courtroom the 2 days when the judge ordered him removed. And essentially, he says, I don't want to proceed if I am not here. I keep telling you the same thing. And the judge's exchange is...
Well, but the judge kept asking him and saying, like, all you have to say is, like, I want to stay here, and then you can stay here, and he would not give her a straight answer on that. So, like, what is she supposed to do in that circumstance?
Mr. Hurt, have a seat at the table. We're ready to proceed and start the trial. At that point, he was not disruptive. He was saying, I keep telling you guys the same thing. Obviously, it was clear from the transcript that he was frustrated. He wanted to remove his trial counsel, and this was only the second pair of attorneys that had represented him. And he's facing, a double aggravated murder case. Sometimes you see these cases where defendants are allowed to fire attorneys up until a fifth set even. So he's unhappy. The first attorneys withdrew. He tells the judge before the trial starts that he's not happy with his trial counsel. They did not come and see him. He's clearly frustrated, and he says, I don't want to move forward with these attorneys. And the judge says, I'm done with this last minute stuff. We are starting this trial today. So when he tells the deputy originally on that first day when he's removed, he says, I don't want to come down. The deputy tells the courtroom, he says that he doesn't think he's getting a fair trial, that he's not happy with his attorneys. They say, bring him down here. They don't have to restrain him or anything else. They go back and they say, Mr. Hurt, come for your trial. He shows up in the courtroom. He tells the judge, she says, do you want to proceed? And that's when he says, I don't want you to go forward without me. And she says, yes or no, and there's that exchange, that kind of combative exchange, yes or no, yes or no, yes or no. And he says, I keep saying the same thing to you and you don't understand. At that point, he should have just been taken to the defense table and they should have started the trial. He was not disruptive. He was not speaking out of turn. He was not yelling. He was not violent. And a lot of these cases...
So did defense counsel say exactly what you just said? Like, at this point, judge, like, just sit him down at defense counsel, we're ready to go. At defense table, we're ready to
No,
go.
the trial counsel did not. When the judge says, all right, I'm done with this, you can just go back to your cell, and has the deputy escort him back, his counsel says, well, I guess he's elected not to proceed. Certainly not the recommended course of action that I would suggest should have happened, but I don't think at that point it was enough to remove him.
Well, okay, let me ask this. Was that issue waived when his trial counsel said that they had developed a litigation plan, cross-examination? We've done that from day one. We will continue to do that, even though he has elected not to comply and not to be in court. Was that waived?
Judge, I would argue that they did not waive his presence at that point. I mean, the court has ordered him already out of the courtroom. So essentially, his trial counsel is forced to move forward at that point. Again, this is counsel he's not happy with. It's clear from the record that they were not getting along, Mr. Hurt and his trial counsel, but I would argue that they did not waive it. And that was only one of the days. He was absent a second day, where he missed 11 witnesses on that second day. And again, it's the same exchange. He shows up in court that second day when he misses the 11 witnesses. There wasn't even a refusal. And she says to him, or the trial court says, are you ready to proceed, or would you like to be here? And he goes, I said the same thing yesterday. And it's just like, okay, well, bye. You don't get to sit for your aggravated murder trial. He misses 11 witnesses that day, and he was not
And so does it
disruptive.
matter from what is your position on like, how do we think about harmless error in this context? Does it matter who the witnesses are, how significant they are, or is your position like, doesn't matter, he wasn't there?
No, my position would be, it definitely matters how many witnesses, who the witnesses were, the amount of trial that he missed. Because what you see in the case law is, okay, fine. For example, during closing argument, he swings at one of his counsel. That's certainly disruptive. I would concede that. Okay, so fine, he misses his attorney's closing argument. I would say that's harmless, right? Missing 11 witnesses over 2 days of trial where he was not able to talk to his attorneys and prepare cross-examination. He had no way of communicating with them. He was not able to observe or hear any of the trial and assist in his own defense. I would say that the amount of time that you miss and the witnesses. For example, there was a gang squad officer who testified on that second day when he was not voluntarily absent or disruptive, who talked about the criminal element in these different neighborhoods. His trial counsel would have no knowledge whatsoever of any sort of confrontation between these two neighborhoods, which was the state's motive for the murder, at least in one case. So also the cell phone analyst, he missed the entire testimony from Sergeant Keppel, who was the one who essentially put the cell phones there at the scene of the crime. So
So given the strained relationship between him and his counsel, was there any evidence from counsel in the record that he actually was collaborating with them and assisting them in everything related to the trial before the exclusion?
I didn't see anything in the record aside from one of the counsel asserting that they had spent so many hours working on the case. But essentially, before the trial started, Mr. Hurt said, they haven't been to see me at the jail. So you have, what he says on the record and what his attorneys say on the record. But given the fact that his attorneys abandoned the motion to sever and didn't even attempt to sever the two murder cases, it gives me pause to know exactly what transpired between the team before
So I have a
trial.
couple of questions. So I think the first hurdle is, how do we characterize this exchange? And so that was the beginning of your argument of like, was this an exclusion where he in some way acquiesced to that exclusion, or whether there was something else going on? So let's say that we get over that and we say, yeah, he was improperly excluded. Then we need to look at whether he was denied a fair and just hearing. My question is this with regard to that. Is that to be determined based on the nature of the testimony that was presented during that time period that he was excluded? Or are you, do you have a burden to establish some sort of prejudice?
Judge, I would argue the nature of the testimony, yes, is one of the court's inquiries. But the prejudice is difficult to establish when he has no lines of communication with his counsel. And even in the most egregious cases that I looked at and that I cited in the brief, where you have extremely combative defendants, there are so many measures taken to ensure that they have a fair trial. They either in a room, even in these little small podunk counties, they're in a little room right next to the courtroom. They're given
Right, but
laptops.
you're going into how he was denied. And so, if we were to agree that he was improperly excluded from the proceedings for 2 days, and there were how many witnesses during those 2 days?
11 for the
11
first day.
witnesses. So how, I'm trying to figure out how we get to whether there was a fair trial in his absence during those 2 days, whether it's simply by the nature and who it was, and, which I think becomes very interesting because it almost puts us into an almost finder of fact kind of position.
Yeah, I mean,
Do you understand what I'm saying?
yeah,
Yeah.
I follow, Judge. I don't know that I have an answer to your question. I apologize.
No, it's okay.
I mean, it's difficult.
I don't know
because-
that I have an answer to my question, so.
Well, I mean, there were so many different witnesses that he missed the testimony on. Several officers, the gang squad officer, the cell phone analyst.
I mean,
crime-
that's what makes it very interesting. You're talking about 11 witnesses, you're talking about evidentiary witnesses, and, you know, is that enough? Because it's evidentiary witnesses, and so whether the accused can, you know, has lost the opportunity to be able to provide, you know, a different information during that time period.
Yeah, it's a difficult question to decide because you don't know what he would have offered to his defense counsel, and he wasn't given the opportunity.
And my question is, do we need to know? Is it enough? Is it enough knowing that there's 11 witnesses, 2 days of trial? Is that enough? Or do we need to know what would have been missed in order to make the determination whether he was denied a fair and just hearing?
I say the amount of time that he missed and the amount of witnesses is enough without going further. Just based on how the cases read about what parts of the trial that you missed. For example, there have been defendants, and they're cited in the brief, that just missed closing argument, you know?
Well, I think that's where my question was going, which is like, is there some presumption of prejudice? Like if you miss like something other than closing arguments where there is actual testimony, do the courts impose some sort of presumption of prejudice, or like whose burden is it to establish that?
Yeah, I don't know that I've seen courts, in the cases that I reviewed, Judge, I don't know that there is an established presumption necessarily. So that's what makes it difficult.
So
I
then
think,
it's
for
the
court.
defendant's burden to establish prejudice.
It is, which makes it difficult when I don't
Yeah.
have anything in the record to show that he was prejudiced. I think the only thing we can look at is the amount of time that he missed and the amount of witnesses, and I think it should be presumed that he was prejudiced by the amount of time that was missed.
Would this be more appropriate for a post-conviction petition?
Based on the errors that I outlined in the brief, Judge, I don't think so. I think that the cumulative errors that we see with quashing.
I'm talking specifically about this assignment of error.
Yeah.
Because it is difficult to discern from the record what he might have provided. Would it be more appropriate for a post-conviction petition?
I don't believe so as I stand here, Judge.
Okay, thank you. If you want to reserve 4 minutes, your time
I
is
just
up.
want to get back,
Okay,
please give me
go ahead.
another one, please, and don't tax her for it, please. I want to get back to the beginning part of your argument to make sure that I understand it, which has to do with the exchange that took place in both of those days when your client was brought down, when Mr. Hurt was brought down, or brought into the courtroom. I think what you're arguing is because Mr. Hurt's grievance was with regard to his representation, and then the court, every time the court asked, well, do you want to stay, yes or no? And if I remember, I believe that Mr. Hurt's response was something like I already told you. He just kept saying, like I already told you, or something.
Correct.
That's what makes it improper, because his grievance was with regard to representation, and it got turned into, it got interpreted into, you don't want to be here.
Correct. Yeah, but he also, you know, says, I don't want to proceed if I am not here. I keep saying the same thing to you.
So he does say that as well.
He does.
And
He
do
does
you-
say that.
And do you happen to recall where in the transcript that is? And if you don't worry about it.
I don't, but I can look.
Okay,
when I
and
sit down.
it's not a big deal.
Yeah, I have it in quotes, so I know that he actually said it, and I remember quoting it in the brief. And the other thing is, usually when a defendant comes in for trial, he walks in and he sits at the defense table. You don't bring him in front of the judge and then engage in this kind of combative exchange, like a fruitless exchange, to try to see where he goes with it so that you can send him out of the courtroom. I think it was improper the way the whole thing was handled both days.
And for clarity, on each of those days, do you recall whether trial counsel in any way complained or objected to the removal of Mr. Hurt after the decision was made of take him away?
As I stand here, I don't believe that he did. I believe the court had made their decision and they just went forward without him.
Okay, thank you so much.
Thanks.
Ms. Lapp, I'll give you an extra 2 minutes to make sure that we give even time here.
and judges. On this assignment of error, there are many, many places in the record where both attorneys said, we have met with him and spoken with him. We have discussed our defense. I mean, it even starts, I believe it's volume 1. There were pretrial hearings like 5 months in a row. And in several of those, Hurt wouldn't come down to court. And the defense attorneys said specifically, we know, this is not his trial, but we want him here. We want him to hear these arguments, and we've been up there and we've been talking to him, and he refuses to come down. Then during trial, many times, they said, we have been speaking with him about it. And I think you quoted one of the places where counsel said, well, several times, they said, we've spent 200 hours on this.
Well, but like, which way does that cut? Because that was going to the question I was asking Ms. Glazer a few moments ago, which is, it's one thing if, like, he's refusing to communicate with his lawyers, and therefore he's not participating in his defense, so the exclusion may not be as prejudicial in that circumstance. Whereas if he is fully engaged and he's assisting them, then does that make it more prejudicial to exclude him in these circumstances?
I do not think it was, because he didn't say, fully participate and keep saying, I want this and I want this. They would go up and check with him. They would talk with him about what was going to be happening. And they would tell him where they were at in court and discuss these things with him. So my point was that it was not that he had never said anything to the attorneys. The lines of communication were open, and I think in the transcript you'll find that. And on the issue, you mentioned issue of fact. You said maybe we're almost determining facts. A voluntary absence of a defendant is an issue of fact. And Hurt's own attorneys used the words, he has voluntarily elected not to come to court. They said it on at least 3 occasions.
What about the threshold inquiry by the judge? And I'm just trying to evaluate the propriety of that. Like, I mean, Ms. Glazer is correct that typically when you bring a defendant into trial, the judge doesn't interrogate him and see whether he wants to sit down or not. Like, he just sits down. So, like, why was it appropriate for the trial court to engage in that colloquy with the defendant here?
It was a gradual thing. The first 3 days, he attended court.
Right.
And there were no problems. And then day 4, he refused to come down. And when he did come down, he said he didn't want to stay. He brought these things up. And that's when the court,
When did he say, I don't want to stay?
well, on day 4,
I mean, specifically, what did he?
I'm sorry, he wouldn't say that
Okay.
he would stay.
I mean,
But-
he actually said that I don't want to proceed if I'm not here.
Yes, but then he would, he would say the opposite of that and say, I don't want to, when the judge would say, well, do you want to stay or not? He'd say, I already said these things. From before trial even started, he was clearly someone who was trying to manipulate the court. At the pretrial hearings, he would sometimes come, sometimes not come. Court starts the first 3 days, he's fine, and he sat there respectfully, didn't interrupt witnesses or his attorneys. Then he starts it on day 4, and that's when the defense put on the record, he has voluntarily stated he doesn't want to comply. And on 3
And
different.
what was the triggering? Was it the deputy saying that he didn't want to come down? Is that what happened on day 4?
Yes.
But then he comes down voluntarily, like he's not,
No, the court ordered that he had to.
right.
So the deputies bring him down. There's no discussion
I
of,
mean, he wasn't resisting that or anything, was he?
yeah, they don't say that when he brought in, he's fighting the deputies or anything like that. So he came in. But then, when he kept being so, he would say so many things that contradicted itself. The attorney said, And at one point, the judge said, send him back up. And one of his attorneys said, Judge, I think we need to have an unequivocal no on the record. So she goes back, tries to talk to him about it again, and he simply refuses to say yes or no. I mean, it was such clear manipulation. This wasn't someone who didn't know what was going on. It wasn't someone who he didn't keep claiming that he hadn't talked to his attorneys, and the attorneys put on the record how much they talked to him. I mean, even the court the one day, I think it was day 5, stated this long statement of the record, not in front of the jury. And she said, a real problem has been that he constantly says he needs a bathroom break, even though we've given bathroom breaks all through trial. So then we come back, he's had it, and then he wets his pants, soils his pants.
So here's the question I have. With regard to waiving presence in the courtroom, Mr. Hertz waiving presence in the courtroom, should that be clear and unequivocal in the record? Or is that something that we can discern by looking at like a totality of circumstances sort of
I
situation?
think you need to discern it. And
So here's my question based on that. If we're going to be discerning it, and it could be read either way, shouldn't it go to the favor of the defendant?
it depends what's in the record. In these cases, you have page after page in transcripts of defendants who know that they can try to manipulate the court this way.
Right, but
and
it's a
they do this to
constitutional right that
stall and
if
to-
it's a constitutional right that the defendant has, and if the record could be read either way, shouldn't we be looking at that in favor of the defendant? Doesn't it weigh towards the defendant?
I think you have to also listen to what his attorneys said. And his attorneys have made a record all through this, that they've been meeting with him. He keeps being defiant, he keeps manipulating, trying to just be in control of everything. And it's not simply saying, because if you simply say, okay, we're going to look at this and see whether the right has been waived, or we're going to rule in favor of the defendants, you will have thousands more cases.
So what
of
you're
defendants.
basically saying is, because this record speaks of manipulation, that it's not a case in which it can go either way.
Correct. Defense attorneys own, at one of the times, Mr. McKenna said he was yelling vulgarities at Mr. Rubenstein. He's extraordinarily disruptive with the witnesses.
Well, he wasn't very happy with his counsel, I think. That's where this whole thing began.
But he had counsel for either 1 to 2 years, 1 to 2 years without complaining. That's something the judge brought out in the very beginning when he was saying he wanted to switch counsels.
Can I ask you a question on joinder real quick? Was this case proper joinder before we get to prejudice?
Yes, I believe it was
Do
proper.
you think it was proper joinder, and how's that?
Yes, you had, when you look at, which was that,
So this is regarding the Norwood
I
counts.
know, which assignment?
It's the third assignment of error. And it's under plain error review.
When you start with Criminal Rule 8 with joinder, and it talks about whether the offenses are of the same or similar character, or act or transaction, or based on 2 or more acts, or connected together with parts of a common scheme or plan.
Right.
In both of these crimes, the same Jeep was used, and it was described in great detail. We have the person who rented it. There's the license plate of the Jeep, barcode of the Jeep. We have witnesses who see 2 men shooting from the car in the same manner in both shootings, hanging out the seats, foot on the running board, the hoodies, the flip-flop. Photographs place both men at or near the scenes. The license plate readers, surveillance videos from businesses and from the neighborhoods, like the apartment complex at President Avenue. Cell phone data, specifically for both crimes.
But is it enough for it to be the same defendants and the same vehicle? For it to be
There was much
common
more
plan
than
or
just the
scheme,
same
or
defendant.
the same part of the same course of conduct?
All of the things that I'm saying were similar in both. And it would be proper because you would be bringing in all of these witnesses twice and doubling up on cumulative evidence. And under the Joinder rule, they were definitely permissible to be in the same indictment. You know, this was one of the first attorneys filed a motion to sever and then got off the case, and the defense said, well, we're going to adopt it, but then they didn't argue it that day in court, and they never brought it up again.
And that makes it really interesting because I don't know this plain error review because it's almost as if we're saying that the bench should have sua sponte done it.
That's Ms. Glazer's argument.
Yeah, I mean, yeah,
And following Criminal Rule
which
8.
kind of puts the bench in an advocacy position, does it not?
Yes. Your bench or the trial court?
No, the trial bench.
Yes, but I think the record fully supports Joinder in this case. There were just so many things in common. And when you can, 404B makes it an interesting discussion.
Right, but I'm just trying to
But I
figure
argued it
out,
was
a lot of
simple.
time when I read these cases, it's really interesting because the joinder itself gets skipped and it goes into the 404B. So it seems like there's a lot more meat to the 404B in case law than the joinder itself. Yet, it has to be proper joinder if you get to prejudice.
Yes.
But
That's
courts like to
why-
get to prejudice and bypass the proper joinder.
But part of proper joinder is the evidence simple and distinct, and then you don't even go through the 404B analysis. And that's why I argued in this that it is simple and distinct.
But isn't the simple and distinct once it's already been joined? I mean, I thought with rule, I mean, you have to go through the Rule 8 analysis first, and then doesn't the simple and distinct come in to determine whether that joinder was proper?
Yes, the case law then goes into explaining Criminal Rule 8 and discusses that.
Okay.
And it is, but this case law absolutely says, if it is simple and distinct, you bypass the 404 analysis. It doesn't need to be.
I understand that part.
Okay.
Okay.
How much time do I have?
You have about 4 minutes.
I wanted to comment on the first assignment of error, claiming that the defense should have been able to subpoena Baltimore. The case law talks about, I mean, yes, there are many cases that talk about when a court should have a hearing on bringing in a defendant, that you're trying to subpoena a co-defendant. And in this case, we had, the best thing that you could was an attorney representing that co-defendant who came in and said, I have discussed this with him fully. He has no intention of testifying. I will not let him testify. I mean, that's an attorney's statement. But showing that there'd be no point of putting him on the stand. And when you have, there are many cases I cite in my brief, when you have an attorney come in and make that representation and the judge accepts it, then you do not need to have a hearing.
So how do we factor in, or do we, the document where he purportedly confessed to this offense? Because, I mean, I realize there's a lot of evidentiary problems with that document, but if it was an affidavit, for instance, where he is voluntarily saying this, that would seem to me to potentially waive Fifth Amendment rights. And so I guess my question is, does the existence of that document warrant some sort of probing beyond simply the attorney saying, I'm not going to let him testify?
There was, the prosecutor was asked questions, put on the record what their reference to this was, because they did give it over in discovery. I think they were being fully transparent with that. But if you read the record, it is so obvious that there's nothing of substance to this, that it was simply, as soon as he said it, Baltimore said it, then he contradicted himself. He told the police something different. It was not an affidavit. It was unsigned. There's no notary. It was a blank document, his own attorney said. It was like a blank document somebody's trying to say he used. It's in the record that Hurt and Baltimore at times had used other defendants or people who were in the Justice Center, used their identifying numbers and tried to pass things off that were not anyone's. And I think there's enough evidence in the record to take away any credibility of that document. Now, as I understand it, they kept saying they wanted it in the Court of Appeals record for you to review. I don't know if that was brought over. You know, I'm talking about,
It was.
okay. But I just don't think there's any question on that issue. And I think the record is so complete on all of these issues that you can find, I mean, I've cited all the pages in my brief, and I think it's all there. And there's just no substance to these issues. Do you have any other questions? All right, thank you.
Thank you. Ms. Glazer, you have 4 minutes.
Just one final thought on that, the second assignment of error, Judge, with respect to removal. If you fight and you're disruptive, and you create the most egregious behavior possible, you even run up on the bench and try to attack a judge, for example, in the cases, you are given so many due process protections to ensure that you're still given a fair trial. You're able to observe, you're able to communicate, live stream, cell phone access to your attorneys so that you can have a fair trial. But if you simply refuse to tell a judge yes or no, you get sent to your cell and you miss 2
Well, I
weeks.
guess that's what I was looking for, like, where's the source of obligation to ensure that the defendant has a means of communicating with counsel during these situations?
Yeah. Are you, I'm sorry, can you repeat your question?
Yeah, like, what case would say, like, whenever there is a separation for, whether it's because you attack someone or you just don't want to go there, don't want to show up in trial, that thou shalt have access to communication with counsel, some mechanism doing that. That's what I was looking for.
Well, I'm sure in the cases that you read, you see mechanisms all the time that.
No, I see mechanisms. My question is, are those mandatory, or is that just something that some judges do sometimes, but maybe not others?
I would argue they should be mandatory. The case law is abundantly clear in the worst set of facts that you're entitled to all those due process protections. So if we were here on that issue, the disruptive, it seems like we're more on the voluntariness aspect of it. And there is no case that will say that the court shall provide this.
Well, I mean, there is case law saying that like a case out of the Second Circuit says that the Supreme Court has never held that a defendant has the right to observe his trial through alternate means. An Ohio case, 5th District appellant did not have an absolute right to watch the proceedings by video. So there are cases saying that the defendant does not have this right. How should we distinguish that?
Judge, I would say that the reason why this case is distinguished from the case that you looked at is the behavior of Mr. Hurt, what transpired in that short exchange, the fact that he had been participating in his trial up until that point. He was involved in his case, the amount of time that he missed, the amount of witnesses that he missed, given that he's serving a sentence of life without the possibility of parole. At a very young age, the confusion that he expressed, the fact that he was not satisfied with his trial counsel, that he was forced to go forward anyway. I think the totality of the circumstances would distinguish his case from the case that the court has examined. If I could touch on,
You have about a minute.
yeah, sorry. The first assignment of error that the state discussed. What I would just like to say about that, I think the document does create a requirement of probing by the court. And the reason why is because it shows that the defense was not engaging in what's called a fishing expedition, which is what you see in the case law, right? So the court made no attempt to allow any inquiry or to bring Mr. Baltimore into court to determine his intention, which is what the Ohio Supreme Court case, State versus Kirk, essentially says. That's the bottom, what the court is required to get to the bottom of. What is Mr. Baltimore's intention with respect to testifying? I think the document gets us over the fishing expedition hurdle. And, you know, the cases that are cited by the state, that State versus Wade and that State versus Spangler case, I respectfully disagree that they stand for the proposition that an attorney can make that assertion on behalf of a defendant, because the first case, Wade, is related to an ineffective assistance of counsel claim because the attorney basically stipulated that a witness was unavailable, so you never really get to the heart of the issue.
Ms. Glazer, your time is up. If
Okay.
you want to wrap up.
Thank you, Judge. And then with respect to Spangler, the court did actually inquire. They put the co-defendant mother on the stand and examined them and allowed the defense counsel to examine them to determine what her intention was. Only after she repeatedly asserted the Fifth Amendment did the court then find that she was not, her presence at trial was not necessary. Thank you.
Okay, thank you. This case has now been submitted, and we will issue a timely decision. That wraps up court for today. Thank you to our guests who have joined us today.